You all ready for this? The Department of Justice just got exposed again. That makes 3 separate hits in under 2 weeks. Every time they move, it looks like we're seeing more of their real intentions come to the surface. Back on May 24th, I covered a case where the DOJ admitted something most of us already knew. They said suppressors are in fact arms, which means they're covered under the Second Amendment. That sounded like a major win. But turns out there was a catch. The only reason they conceded that point was to defend the National Firearms Act's registration and tax scheme. Because now, with lawsuits targeting that registry, the tax portion has been stripped away. And suddenly, the government wants to keep the registration requirement alive at all costs. Makes you wonder, was this the plan from day one? You tell me. All of this is unfolding while the current administration pats itself on the back, claiming a victory over deregulating suppressors. That happened after gun owners of America got language slipped into what they called the Big Beautiful Bill. So what's the DOJ really trying to accomplish here? For the very first time, a federal court just labeled the NFA's licensing scheme presumptively constitutional. That's never been said before. The court claimed it functions like a shall-issue system. That is a dangerous precedent. Time and time again, we see courts twist language in ways that shrink our freedom. And what just happened yesterday is no different. What if I told you the Fifth Circuit handed down a decision on suppressors that could change the Second Amendment landscape going forward? The Firearms Policy Coalition is already calling it flawed and dangerous. Today we're going to walk through that case, United States versus Peterson. We'll break down why the court sided with the government, and why gun rights advocates say this ruling puts every one of us at risk. Let's get into it. The case dropped on August 27, 2025. The central question was simple. Do the NFA suppressor registration requirements violate the Second Amendment? The Firearms Policy Coalition wasted no time. They came out hard against this ruling, warning it sets a dangerous path. Here's the backstory. George Peterson owned a small firearms business out of his home in Louisiana, operating under the name PDW Solutions. In 2022, ATF agents raided his property after an extended investigation. During that search, they found a suppressor built from a kit, stored in a safe inside his home. It had no serial number, it wasn't registered, and it clearly didn't comply with the NFA process. That's all it took. A federal grand jury indicted Peterson under the National Firearms Act for possession of an unregistered suppressor. The charges were tied directly to 26 U.S.C. Sections 5841, 5861D, and 5871. Peterson didn't roll over. He filed 2 separate challenges. Number 1, a Second Amendment claim, arguing that suppressor regulations under the NFA are unconstitutional. Number 2, a Fourth Amendment challenge, asking the court to throw out evidence from the raid because the warrant was defective. The district court denied both. So Peterson entered a conditional guilty plea, preserving his right to appeal those issues. He did exactly that. The Fifth Circuit Court of Appeals reviewed the case, and in the end, they upheld the conviction, siding with the government on both counts. First up, the Second Amendment side of the case. The court assumed, without making a firm decision, that suppressors are in fact arms. But here's the trick. They claimed the NFA's entire licensing structure is presumptively constitutional. Why? Because they said it looks like a shall-issue system. Now that logic comes out of the 2022 Bruen decision. Remember, Bruen struck down may-issue licensing, but left the door cracked open for shall-issue laws if they're objective and consistent. So the Fifth Circuit grabbed that and ran with it. They pointed out that the NFA requires fingerprints, photographs, a background check, and a $200 tax. And since the only denials come when someone's already prohibited, they said it qualified as a shall-issue regime. That's garbage. Peterson never filed an application, never paid the tax, and even admitted he forgot the paperwork. So the court basically said he couldn't prove his rights were actually denied. Second issue, the Fourth Amendment. Peterson argued the ATF search warrant had no probable cause. The court brushed that aside with the so-called good faith exception. meaning even if the affidavit was thin, the agents acted as if it were solid. So, suppression of evidence was off the table. Bottom line, the Fifth Circuit upheld the conviction, tossed out his Second Amendment challenge, and kept the suppressor evidence in play. But here's the kicker. As of January 1st, 2026, the NFA's tax requirement is gone. If the Supreme Court has already said the NFA is nothing more than a tax scheme, then once the tax falls, the whole foundation should collapse with it. At least that's the way it ought to go. The Firearms Policy Coalition didn't waste any time calling this decision deeply flawed. And here's why. First, suppressors are clearly arms. They attach to firearms. They make shooting safer by protecting hearing. They're useful in hunting. They're valuable in self-defense. And by law, Congress itself defines them as firearms. Even the government admitted that much. But the court refused to lock that down. They ducked it. Second, the shall issue argument is stretched beyond recognition. Bruen talked about concealed carry permits, quick background check, clear standards. That's a whole different world from the NFA. Under the NFA, you're looking at months of waiting, fingerprinting, photographs, and taxes. That's not the same thing, and it's not constitutional. Third, the court ignored the real burden. Peterson said the wait times for suppressor approvals can run 8 months or longer. The government said it's just a few days now. The judges shrugged, said Peterson didn't prove it either way, and sided with the government. That's dangerous thinking. Because in reality, thousands of gun owners get stuck waiting and waiting while their rights sit in limbo. Fourth, this ruling opens the door wide for abuse. By calling the NFA presumptively constitutional, the court just handed the ATF cover to keep grinding Americans down with paperwork and restrictions. Now here's why this matters. 2 major lawsuits are already challenging what's left of the NFA. The tax is gone, and if the NFA is nothing but a tax scheme, then the registry has no constitutional legs to stand on. The Department of Justice knows this, and this decision looks like a setup to defend keeping the registry alive even without the tax. So where does that leave us? For now, suppressors are still trapped under the NFA. The Fifth Circuit leaned on a twisted interpretation of Bruen to keep them regulated. And the Firearms Policy Coalition is warning that this precedent is dangerous. The court did admit future challenges might succeed if they bring stronger evidence of long wait times or abusive fees. But Peterson wasn't that guy. He never applied. He never paid. So the fight continues. This ruling proves one thing: our rights don't erode all at once. They get chipped away piece by piece, case by case, unless we stay vigilant. That's why groups like FPC, GOA, and SAF keep hammering these cases in court. And that's why we have to stay informed. So what do you think? Should suppressors be treated like any other firearm accessory? Or should the government keep them under NFA control? Drop your thoughts in the comments. And if you got value out of this breakdown, make sure to hit like, subscribe, and share this with your friends. Stay safe, stay vigilant, and above all, stay free. I'll catch you on the next one.